I call to order the regular meeting of the Oradell Zoning Board of Adjustment for November 18th, 2024. It is 7:30 PM. Notice for this meeting was published in the official newspaper, promptly posted in Borough Hall, and filed with the clerk's office in accordance with the requirements of the Open Public Meetings Act. This meeting is a quasi-judicial proceeding. Decorum appropriate to a judicial hearing must always be maintained. Any questions and comments must be limited to issues that are relevant to what the board may legally consider in reaching a decision. Roll call. Mr. Barrows.
Here.
Mr. Bartlett.
Here.
Mr. Devine.
Here.
Ms. Zadinsky.
Here.
Mr. Camporielli is absent. Ms. Day.
Here.
Mr. Santaniello.
Here.
Ms. Cobb.
Here.
And Mr. Michaelman here. All right. Pledge of allegiance, please.
I pledge allegiance to the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Next, approval of zoning board meeting minutes for October 21st, 2024. Does anybody have any changes to the minutes as submitted to you? Okay, not hearing any. May I have a motion to accept the minutes as submitted?
Also move.
We have a motion. Do we have a second? Sure. Motion and second. All in favor? Aye. Any opposed? No. Minutes are approved. Correspondence, that's listed in the agenda. You can see it on the screen, for those of you who care to look. If you want that, correspondence is available in Steve's office for anyone who wishes to review that. Zoning board procedures. When someone in the borough wishes to do something to their property, house, building, whatever, they go to Steve's office and ask for a permit. If it's something that's acceptable in the zoning code, they're given the permit. If not, Steve has to deny the request, and under certain circumstances, they can appeal that denial to the Zoning Board of Adjustment. We operate in the nature of a court. It's up to the applicant to demonstrate that they should receive the approval to do what they want to do. It's not up to us to justify the denial. So the applicant has to put forward their proofs to demonstrate that they're entitled to that. If they do so, a majority of the board votes on that and says yes, they get the approval. If they haven't proven their case according to the judgment of the board, we deny it. And of course, that can be appealed to the court or to the council in certain circumstances. Okay. Now, if you would swear in, actually, has
I think
everybody?
they've all been sworn
Yeah.
because there have been multiple
Yeah,
hearings on
right,
every application.
Right. Normally, we would swear in the professionals, but they have already been sworn in for
They
all three.
remain under oath.
And they remain, thank you, they remain under oath. Now, no new cases will be started after 10:30. What we're going to do is have 3 hours of testimony. Each case, we have 3 cases, will have up to 1 hour to present their case. At about 9 o'clock in the evening, I'll give a 10-minute recess so people can stretch their legs, go to the restroom, make phone calls, whatever. With that, there's no resolution. So first thing is Christian Brothers Institute. That's Bergen Catholic, the field. We've approved that, and actually, it's underway. And in my opinion, I don't know why we even have to grant an extension because they've already done it. But our attorney feels that it would be wisest to follow proper procedure and grant them an
Chairman,
extension.
for the record, I haven't given an opinion on
Oh,
it.
no, that's correct.
And you all know why.
Yes. Our attorney is a graduate of Bergen Catholic and therefore has recused himself. It was a different attorney who had handled that case, and that was the opinion. So it's still an attorney, not that guy, okay? That we just are safest by moving forward. You have everybody on the board, you have the request for this? Does anybody feel that this should be discussed, or can we simply vote and approve it? All right.
I move that we send it to a vote. Or,
Okay, yeah, we're certainly going to put it to a vote, so do you move to, okay,
to
do
approve the
we,
extension.
do we have a second? Somebody give it a second so we can move on this, okay. All right, Steve, would you call the roll, please?
Ms. Day?
Yes. Agreed.
Mr. Bartlett,
Yes.
Ms. Odinsky,
Yes.
Mr. Barrows,
Yes.
Mr. Devine,
Yes.
Mr. Santaniello,
Yes.
Ms. Cobb,
Yes.
and Chairman Michaelman.
Yes. Okay. So that motion passes. If you would, I think, you can still put together the approval letter, or do we, to,
It'll be done, I think, by...
okay, Steve, you'll take care of the approval? Let them know that we've approved
Touch
it?
that one, Mr. Chairman.
That's right, yes.
We
Steve.
will.
All right, I don't want you to dirty your hands on that. All right, with that, it is 7:35, and we'll move on to BCUW Madeline Housing Partners. So, sir, if you would come forward. And Mrs. Santaniello is stepping down from this case,
Zadinsky as well.
and Ms. Zadinsky as well. Thank you. Sir.
Evening, Mr. Chairman, members of the board. For the record, Bruce Whitaker from the firm McDonald Whitaker, representing the applicant. This is a continuation, as you know, of the public hearing. At the last meeting, we had presented David Halls as a professional planner. He testified on direct and provided you with the planning information and the justifications for the relief that we are seeking. On the basis of that, we concluded his direct testimony, and Rob Simon started the cross-examination. I understand that's where we're going to continue with tonight, with alternate counsel from his firm. And then on the basis of that, I reserve the right to recall Mr. Halls for any rebuttal. And then we will have one other witness thereafter, if we can get to it. I know we have an hour. David Hall still under oath.
Thank you. I hope so.
Good evening, members of the board. I am alternate counsel for Mr. Simon. My name is Christine Faustini. I'm from Herald Law, and I'm here representing several objectors who you've heard from Mr. Simon before. Would you like me to read their names, or are we good?
No, we've heard them before unless there's anyone new, but they are aware that any questions or comments will come through you. They do not individually appear.
Thank you, sir.
Thank you.
Before I proceed, I watched the video of the last hearing so that I'd be able to be prepared and hopefully not duplicate. But I believe there was an exhibit marked A14 that Ms. Ryder was going to look at. And so that, again, I don't duplicate, I didn't know if you wanted to hear from her on that exhibit before I proceed with my questions to Mr. Hall, or if you wanted to discuss that first, just again, so I don't duplicate stuff.
Carolyn,
Was that the alternate parking plan that you're
Yes.
referencing?
Yes.
Right, so, thank you. So, Mr. Chairman, members of the board, at the last meeting, the applicant presented an alternate parking scheme, I believe labeled as A14. And that scheme showed the same number of parking units, but I believe it pulled the parking lot, parking area closer to the road, and it also resulted in the elimination of the lot coverage variance. And there was also testimony that I believe 3, potentially 4 trees might need to be removed as a result of this parking scheme, should that be the alternate that is utilized. And I believe what council is referencing is, I think I made a comment like, I need to look at this offline because I hadn't had the opportunity to see it prior to the last meeting. So we've looked at it. I will note that it does, eliminate the variance, although it brings it right to the threshold of the variance, what would potentially, right below where the limitation up for the variance. It does result in the removal of, I believe, 3, potentially 4 trees. It's, of course, the board's decision. I would, due to the potential tree loss, I would recommend utilizing the original parking scheme, although that does require one more variance. But that would be my recommendation as your planner. But of course, it's all your decision.
thank you.
All right, so if I may, I will proceed with the original plan, based on her representations to the board. And
So
just
you
question.
decided to go with the original plan?
Well, I'm going to question on that unless the applicant wants me to question on the second one.
Well, tell us which one you propose, all right, go ahead. I don't want to interfere with you.
I'll just go ahead, sir.
But just the record reflect that the applicant was comfortable with either one, and it was up for a board to make the decision.
Thank you.
I think, so I'll proceed, and then we'll let the board decide later. Okay, so Mr. Halls, at the last meeting, you provided some opening testimony. I have additional questions for you, since this is an affordable housing project. Have you ever done a housing element and fair share plan for any municipality?
Prepared the plan? No.
Have you ever testified in any affordable housing projects as a planner?
Yes.
What municipalities were those projects in?
Where I've done projects that had an affordable housing component, Mawa, Allendale, Wyckoff, Fairlawn, probably, I can keep going, I gotta think. Montvale, Paramus, Montville, Ringwood. I'm,
It's okay. If I may then, were these all projects that were being constructed by BCUW?
no,
Were these municipally sponsored projects?
none of them were. Oh, yeah, some of them were, none of them were. Some of those were,
Okay,
some of those were.
all right. Can you give me an estimate as to how many of those projects were municipally sponsored projects?
Municipally sponsored, I'd probably say, out of municipally sponsored projects, I've probably done a dozen or so.
Thank you. So, as I understand it, this project has 4 units on the ground floor and then 2 apartments on the second floor, correct?
Yes,
All right. NJSA 40:55D-40, 66.2A distinguishes between group homes and supervised apartment living arrangements in defining a community residence for persons with developmental disabilities. Is that correct?
I'm not sure about the specific section.
The proposed apartments, from what I understand, are only functionally connected to the group home by sharing a common, is it a rec area?
Community room,
A community room. Otherwise, the apartments have their own kitchens, their own living rooms, their own bedrooms. Is that correct?
as I understand, yes.
The town's ordinance provides a community residence, as defined by the statute, shall be permitted in all residential districts of the borough and shall be subject to the requirements of single-family dwelling units in such districts, subject to certain exceptions. One of those exceptions is that any such residence having more than 6 persons, excluding resident staff, shall require a conditional use permit. So, shouldn't that ordinance provision apply to this situation?
I'd have to read the section again, but I don't believe so. I mean, you have a 4-bedroom group home, that's 4 residents are in the one's in the group home. It's not a 6-person, it's not a 6-person home.
It's 6 units.
Right.
Yeah,
Well, it says any such residence having more than 6 persons. Aren't there going to be 6 persons residing in what is this one building?
no, there's 4 people in the group home, and then there's independent apartments. And
But,
there won't be 6, I don't believe there's gonna be 6 people, independent people in each, any of those units.
It's,
And there was a ruling at an earlier meeting that this was looked upon as the group home.
Right.
And that
I
it
think
fits
the
within the
statute
residential
controls.
district. And the statute, and that was a ruling by council. And concurrence, as I recall, from the borough planner.
And I haven't seen any submission contrary from the objector on that.
I'm sorry, I'm going to need, if you mind, I'm going to need you to clarify. You're suggesting that the 2 apartments and the 4 downstairs units all comprise one group home? Is that what you're telling me?
Yes.
Okay, so we have one group home that contains seven beds, correct?
How many beds? There's six, there's a total of 2 on the second floor and 4 on the first floor.
There's 3 beds on the second floor, correct? There's a 2-bedroom apartment and a 1-bedroom apartment on the second floor. That's 3 beds, correct?
I don't know.
Well, it is. It's 3 beds. You have 3 bedrooms on the second floor, 4 bedrooms on the first floor. That's a total
Excuse
of
me, should you
7.
be questioning the board's attorney?
I'm sorry. You were brought in
I've given
because
my
you said there
opinion
was a
that the
rule.
statute controls, ask away.
Right, the statute controls the group, that it's a group home. Is that what you're saying to me? Sir, I'm
I've given
sorry.
my opinion.
Okay.
I'm done debating the issue.
All right, the ordinance, though, talks about community residences. And according to the statute, a group home qualifies under the statute as what's defined as a community residence for persons with developmental disabilities. That statute, 40:55D-66.2A, says that community residence for persons with developmental disabilities shall include group homes, supervised apartment living arrangements. The town's ordinance refers to that statute, and it says that provides its community residences as defined. That statute breaks it down into 2 types, and more than 2 types, actually. And what is going into this one building is 2 different types as defined by the statute. Those 2 different types contain a total of 7 bedrooms. And under this ordinance, it says any such residence having more than 6 persons, excluding residence staff, shall require a conditional use permit to be granted by the planning board. Have you already, I'm sorry, sir, did you already render a decision that there's no conditional use permit required?
I gave an opinion that the statute, we're governed by the statute and that controls.
Okay.
And I haven't heard anything in contrary from the objector disputing that until now.
Okay, so you've heard it now. In addition, well, again, under this ordinance, it would require there be at least 1 parking space for each proposed resident and staff member. Is there going to be, again, assuming this applies, is there going to be 1 parking space for each proposed resident and staff member under the proposed plan?
Who are you questioning, me or
I'm
Mr. Hall?
questioning Mr. Hall.
I'm confused.
Yeah,
I'm sorry.
I
Mr.
was confused too. The parking we're providing, as we're providing the 6 parking spaces, and the parking spaces on, for the second floor are 4 parking spaces for the second floor and 2 parking spaces for the group home. The group home residents do not drive.
And the RSIS standards comply, and they require 7, and we're providing 8. Now, RSIS supersedes any local ordinance.
Before you continue, excuse me, the statute, the ordinance, I think it was the ordinance you referenced, mentioned that you'd have to go to the planning board for an item. Are you suggesting, I'm talking to you, counsel.
I'm sorry. Go ahead.
Are you suggesting that the zoning board lacks jurisdiction?
No, I'm not suggesting that.
Then would you explain the mention of the planning board?
I am trying to draw to the board's attention that you have an ordinance on the books that could potentially require a conditional use permit. And you are now in this position where this is one of the factors for you to consider. That's why I'm presenting it to you. I'm not saying that you don't have jurisdiction, but I believe you have the right to decide that this actually applies or should be considered just to the extent of this ordinance. Obviously, the governing body, whichever iteration of the governing body, felt it was important to put in this additional parking requirement.
So, if I'm understanding you, you're saying that this board must also consider a conditional use variance?
It should consider it a conditional use. I believe that was advertised as part of the notice. Am
Okay.
I correct, Mr. Whitaker?
I'd have to go back and look.
let me
That's 6
see.
meetings ago.
I have a copy of
Doesn't, the
those.
board has jurisdiction
Jurisdiction,
anyway.
that's right.
If it's a D3.
Right, but what you are considering as part of this application, you have an application that includes parking, it includes lots of other factors, and it's something that I'm presenting to you, that even if you decide, even if you were to decide, and I believe it was put into the notice,
Yes,
so it was put as part of the notice that it might be required. But in addition, even if you don't choose to make them to require that, you should consider this ordinance in terms of, is this appropriate? Is this proposed building that has 4 group home units on the downstairs and 2 apartments with 3 bedrooms on the upstairs, is this appropriate for the site? These are all part of the pieces of the puzzle. That's what I'm trying to present. Okay? Does that answer your question, Mr. Chairman?
Yes.
Okay. I know you guys have put in a lot of time. I don't want to sit there and say this has all been wasted for you, so I'm trying to be clear as to what we're doing. But it shouldn't be a surprise, I don't think it's a surprise to Mr. Whitaker that Rob Simon certainly did discuss whether a conditional use variance was required, a conditional use permit was required. All right. So the upstairs of the second floor, do you know, Mr. Halls, as I said, it's my understanding there's 2 bedrooms in one unit, and there's 1 bedroom in another. Could a couple reside in 1 bedroom, or is that not going to be permitted?
I don't know.
all of the discussion about occupancy and how these operate were done by a prior witness, Mr. Toronto.
Yes, but I think it's also a planning issue, and Mr. Halls is here as a planner. I mean, what we are looking at potentially is if in fact that bedroom could be inhabited by a couple, then you have 1, 2, 3, 4 people living on the second floor. All right,
Would that make it not an inherently beneficial use?
excuse me?
Would it still be an inherently beneficial use?
Well,
Just asking. You're asking questions of me, I'm asking that of you.
I believe it is still qualifies as an inherently beneficial use under the statute. And in that regard, it has to be, but you have to consider the negative criteria. And that's an important factor. In addition, because it's an affordable housing project, does not mean that the board should not consider the municipal land use law, the purposes of the municipal land use law. And the purposes of the municipal land use law talk about safety and public welfare and flooding and various other factors. Would you agree, Mr. Reagan?
General welfare, section A of 4055D-2.
Good.
I cite it every day.
We're on the same page.
Right.
All right. I'm trying not to duplicate, so if you'll just give me a second. All right, so as of right now, the applicant's requesting a D4 FAR variance relief, correct?
That is correct.
Would that FAR variance be eliminated if you eliminated the units on the second floor?
I don't know exactly.
But that's not what's proposed. We have to talk about what is proposed here. There's been no representation that anything would be eliminated. It's 4 downstairs and two units upstairs.
Well, I understand that's what's
It's in
proposed.
conformity with the amendments to the housing element and in conformity with the agreement between the governing body of Oradell and this applicant.
It's part of the borough's housing plan.
Oh, I am so happy you brought that up. So we're talking about the 2022 amendment to the Housing Element Fair Share Plan, which I happen to have here. First of all, Mr. Hall, have you read this 2022 amendment to the Housing Element Fair Share Plan?
I have, yes.
Okay, so are you aware that on page 7 of this Housing Element Fair Share Plan, it says it is important to note that Oradell has met its round 3 affordable housing obligations?
As the author of this plan, can I jump in at this point? I'm sorry, Mr. Chairman.
Please, go ahead.
I believe that reference, although it's been quite some time since I wrote this, let's go to, where are we at, page 7?
Page
Although at a
7.
different firm, I actually prepared this plan. So perhaps we can assist, because I don't believe Mr. Halls was at all involved with the preparation. I'm sorry, did you say page 7?
Yes,
Which,
it's the second sentence under conclusion.
right, so I can tell you that reference was towards the RDP, which I believe was 7, and I believe was addressed in various manners. I think that the purpose of that statement was to, to show how actually proactive and how responsive the borough is with respect to its affordable housing obligations.
And it is very responsive. And in fact, you're correct. I agree with you. It satisfied its RDP for the round 3. And again, according to page 5 of this Housing Element and Fair Share Plan, it says, Bergen County United Way project is an unmet need mechanism. Mr. Hall, can you explain, do you know the difference between an RDP and an unmet need mechanism?
No, not exactly at the moment.
Okay. In addition, this Housing Element and Fair Share Plan, and this is back to this is proposed, right? You have a group home proposed on the ground floor, and you have these 2 independent apartment units proposed on the second floor. And part of the reasoning that has been put forth to the board, and Mr. Whitaker just did that, which is why I looked at this document, is to suggest to the board how important this is to the town to satisfy its affordable housing obligation, according to this document. And according to this document, Ordell, being so proactive, had in fact satisfied its RDP, has already done that. And in addition, Ordell picked up, if you look at page 5, it says that in addition, because of some of the more recent approvals, Ordell picked up 3 affordable housing units from a project that was approved by the Board of Adjustment in August of 2021. In addition, they picked up another unit from the Planning Board when it approved a project on Kindermack Road. So as far as this document goes, the town satisfied its RDP, and yes, Bergen County United Way is mentioned in here, is also though mentioned because, again, Mr. Whitaker keeps relying on this document as a reason for why this project has to go forward. It's mentioned the Bergen County United Way project is discussed, and it's discussed as being proposed. That's also on page 5. It says the borough has agreed to donate the property to Bergen County United Way, which proposes to construct a 4-bedroom group home and 2 separate apartments. Again, the borough, in terms of this document, its 2022 amendment, should really commend itself because it satisfied its RDP, and it's also picked up additional affordable units.
I
So-
don't want to interrupt the flow, but I'm hearing advocacy. Shouldn't you be just asking questions of the witness at this time?
Well, I tried to ask questions of the witness, and the witness didn't recall the document.
Well,
You
then
can verify.
Then it was asked and answered.
So, yeah, so that was it.
Can you move on?
It's not time for a summation, it's a time for questions.
That was my
All right,
point,
well,
thank you.
Mr. Hall, was anything I said inaccurate? To the best of your knowledge?
I read this document as meaning that after it had gone through all the different specific projects, the one on New Milford Avenue, the Central Business District, the affordable housing overlay on White Beaches, and then the others projects it lists through here, going through, and then it talks about the recent approvals. Based on all that, the conclusion is that the borough has met its round 3 affordable housing obligations. Not that it met its affordable housing obligations before those are implemented. So you're taking the conclusion at the end and putting it in the front, and I think that's incorrect.
And it's the representation, as I recall, that was made in connection with their settlement for the 3rd round.
Well, like I said, the document kind of speaks for itself. It says very clearly on page 5 that the Bergen County United Way project is an unmet need mechanism. And it also says this project is proposed as. But am I incorrect with what it says?
I stand by-
Document speaks for itself.
I stand by what I just said.
All right, I'm not asking questions of Mr. Whitaker. I'm trying to ask questions of Mr. Hall. And Mr. Whitaker keeps speaking, which is why we keep having this mayhem among the lawyers. But Mr. Hall, can you answer the question?
Yeah, I did before. I believe that the document is talking about all the affordable housing projects within Oradell and how they apply for the housing need. And with the Bergen Canyon United Way project in here, this is why it meets the housing obligation.
Well, as I said, you just, when I asked you about the FAR, you don't know if they remove the second story, if that will reduce the FAR. Is that your answer?
That was asked and answered.
You didn't review style and aesthetics of other homes in the neighborhood, did you?
Repeat that, what?
You didn't review style and aesthetics of other homes in the neighborhood, did you?
No,
You didn't compare the square footage of the new building to other homes in the neighborhood, did you?
I did not.
Do you know what the average square footage of other homes in the neighborhood is?
Average, no.
No other residential building in the neighborhood is as massive as the proposed building, right?
This, there aren't buildings larger than what is proposed here.
So the building will be the biggest in the neighborhood in terms of square feet, right?
I believe so.
So the building is not consistent with the scale of the homes in the neighborhood, right?
Well, it's consistent with the size of the piece of the property we also have the largest piece of property within the neighborhood. So in scale-wise, it's consistent with the neighborhood.
What about the length of the facade? Is it more than 100 feet longer than, let's say, 1.5 stories?
You'll have to, the facade? I'm confused what you're asking.
Do you know what a facade is? Do you understand that
You
question?
asked, what is the facade and the height?
Oh, facade.
Facade.
Facade. I thought you were saying sod, like in grass.
I'm sorry, facade.
That's, ask the question again, I'm sorry.
Is the length of facade more than 100 feet long?
I don't know specifically the length of this building.
What about the floor area ratio of the new building compared to those in the neighborhood? Did you compare those?
I didn't look at the percentage of the other houses in the neighborhood. I don't know that there's, what the percentage of those houses are in relationship to their properties.
Is there anything to prevent the applicant from designing a different layout of the building so that they could reduce the number of residential units?
That was already discussed with the architect previously.
But you're the planner, and this has got to do with what is appropriate for the zone, so can you
This is
answer?
the proposal that both the applicant and the 2022 amendment for the housing plan were proposing for this piece of property, and that's what the application is.
So you don't have an opinion as to whether this can be constructed smaller?
Constructed smaller, the architect had testified that it could not be constructed smaller, to still be a four-bedroom group home and have the two independent units, the supportive housing on the second floor.
Do you have any knowledge regarding the frequency of visitors to the cemetery nearby?
Only when I've been to the site. I've never seen anybody visiting the cemetery.
Do you have any planning concerns about locating this type of project so close to a cemetery?
Planning concerns?
Yes.
No, the cemetery is a very quiet use, and I don't believe that this proposed use will have any impact at all on the cemetery.
Do you know, and again, this is sort of a new question because I think this was asked before, but maybe your answer is going to change. Do you know what type of group home, like what the nature of the group home residence is going to be? Like what type of group home it's going to be?
Well, it's supportive housing. That was testified by Mr. Toronto.
Yes, but there's a variety of supportive housing types of facilities. There's head injury facilities, there's developmental, there's a variety of group homes and supportive
These are
housing.
not, again, that was testified too. This is not head injuries. These are developmentally disabled individuals.
Physically or mentally developmentally disabled, do you know?
All of this was testified to by Mr. Toronto in the opening hearing.
Yes, but I'm talking about planning concerns
It
and
could be-
putting this
it
near
could-
a cemetery.
It could be both physically and mentally, because you do have, well, it could be both.
Do you know how many homes on Gunther Avenue are eligible for the National Register of Historic Properties?
I do not.
Are there homes, residential homes, regular residential homes adjacent to the proposed parking lot?
Are there residential homes?
Single-family homes adjacent to the proposed parking lot?
Yes. Yes.
There are 12 homes within 200 feet of this lot, correct?
I don't know the number of houses within 200 feet.
Do you know the average lot size for the residences in the neighborhood?
I know what the zone district is. I don't know what the average house size is.
Do you know what the average lot width is in the neighborhood?
Again, I do not know that.
You have visited the site, correct?
Multiple times.
All right. Is the size, shape of the structure similar to any of the surrounding residences?
Is it size, shape? No, the other homes are single-family homes.
So the proposed site layout is not similar to that of surrounding residential buildings either, correct?
It's as I mentioned before in my testimony as the engineer, the proposed parking area is consistent with the proposed group home and the additional apartments.
There are no parking lots in the neighborhood, correct? Other than the
Well,
ones
they're not
proposed.
striped parking lots, but each of the homes do have a driveway, and that is a parking area. For each of the homes do have a parking area.
But the proposed will have a striped parking lot, correct?
It's going to have a surface parking area. We could remove the striping, and it would be consistent with all the other driveways. The only difference between this is we have striped parking spaces.
Besides single-family homes and this proposed community residence, are there any other uses in this R4 zone?
Are there any other uses in the R4?
In this R4 zone?
What do you mean by this R4 zone?
Well, this property is located in an R4 zone.
So you're going to talk about other uses in the R4 zone all throughout Oradell?
No, just this one.
Well, what's the zone you're describing?
How many R4 zones are there?
Yeah.
Once
We're
you
going to
know-
go through a litany of what uses are in the R4 zone all through the borough of Oradell?
Absolutely not. This property is this property located in an R4 zone, Mr. Halls?
Yes.
All right. So in this R4 zone where this property is located, are there any other uses other than single-family homes located in this R4 zone that includes Gunther Avenue?
In the immediate vicinity of the site, they're all single-family homes.
But you're not aware of all the uses in this R4 zone, correct?
I'd have to go to the limit. I didn't walk the entire zone district.
All right. Is it true that the grant of a use variance always represents an exception to the generally applicable zoning scheme?
I always.
Could you repeat that
I'm
question
not
again?
quite sure.
I'll rephrase it. How's this? The grant of a use variance always represents an exception to the generally applicable zoning scheme, and because of the legislature's strong policy
Well,
preference.
that's not a question.
I'm getting to the question part.
Hope so.
That was rude. Please, let me finish. And because of legislature's strong policy preference for planning by ordinance, only exceptional cases warrant use variances, right?
We're required a D4 use variance for the FAR. I'll answer it in that fashion.
That's all I have. Thank you.
Thank you. Do we have any other counsel? No.
Mr. Whitaker may,
I'm gonna do redirect by
Redirect,
reserve.
Please.
Okay.
Do you wish to do that now, or shall I open it to the public?
Well, is there more questions?
no, I think the redirect should be done first. I think.
Okay.
Any more questions, though, Mr.
No,
Hall?
she's finished with her questions, but members of the public may have questions.
So they should ask their questions, and I can do redirect?
That's fine.
Yeah.
If you want to do it that way, okay.
Do
Does
it.
any member of the public have any questions of the witness relating to his testimony? Sir?
Not represented by counsel.
No, he is not represented by counsel.
No, he was.
Paul Latsunas, 50 Beverly Road.
I'm sorry, your name again?
Latsunas, Latsounas,
And your address?
50 Beverly Road.
Thank you.
Good evening. Do you know why the side street has a name? Do you know what the name of the side street is there?
Objection irrelevant.
No, it's very, very,
What
very.
difference does it make what it's named?
Why we name streets is very, very,
What relevance does the name of that street have to this case? That's what they're asking.
because of the name itself.
The name of the street itself has
Yes.
relevance.
Would you move the picture over so we can see what the name is?
I'll answer the question. It's
Please.
Brookside Avenue.
Ah, yes. Okay. Brookside. Reference to a brook, maybe? What do you
Question,
think?
Is
please.
that a question?
Is it a reference to a brook, too? Could the street name be a reference to a brook?
I didn't name I can't answer the question, so.
Okay. Well, the name itself is important. Have you ever witnessed a storm surge coming down Brookside from Kinderkamack Road?
Haven't we had previous testimony about storm surges?
The testimony was when he was an engineer, and the cross-examination of him as an engineer took place a meeting ago. And he testified to all the drainage aspects at that time.
The question was never answered. You can go back and look at it. That question was never answered as I asked it.
But this is not the individual to ask that question. He's a planner, he's not the engineer.
Oh, here's a
Well,
plan.
he is the engineer, but we conclude
No.
the engineering
Engineering
testimony.
testimony is done.
I would think that a planner would know something like this. That's why I'm asking him. I mean,
I'll
if you're
leave it to you
planning
if you-
something
hold-
and you.
Hold on.
and you know there's-
Hold on.
Yeah.
I'll leave it to you to determine whether you want the.
So the question is, do you know of any flood situations or water surges on Brookside?
Personally, no.
Good. Next.
You said personally. Do you know of anybody else that may have
Objection irrelevant.
something about
Can't
that?
do that.
He can't testify what other people might
Okay.
know. Speculative and conjecture.
Yeah, well, he's eliminating himself. Okay. All right, we'll go on to something else. So I'll bring that up in the summation at the end.
Perry Mason.
The one parking spot that you intend to make, you want to remove 4 trees, is that so?
If we move the parking lot towards Genther Avenue, we would remove 4 trees for that.
Okay.
Or
Do you,
3, I'm not sure if your number is correct, I'd have to go back.
do you know the diameter of those 4 trees?
It's on the plans. I think I testified to this last time. I'd have to look.
You can't recall?
Not at the moment.
Plans speak for themselves.
Okay. Okay, on the apartment space of the downstairs on the first floor, do you know how many square feet each one of those rooms is?
That was testified to by the architect. He did not testify to it as the planner.
Okay, he doesn't know. Okay.
It's not that he doesn't know, it is not part of his testimony.
So he doesn't want to answer
No,
because
it
it's
is not part of his
Oh,
testimony.
okay. It's convenient. Okay. Okay, I understand that those apartments on the first floor are going to be using a common living area.
Question, please. He's now getting involved in testimony, he hasn't been sworn.
I haven't finished my sentence, sir.
Ask your question.
Okay. Are the apartments downstairs going, on the first floor, going to be using the living areas upstairs on the second floor?
The first floor is a group home, and the independent living is on the second floor. So the people on the first floor will not be going to the second floor.
So it's not a common area?
The common area was the community room on the first floor.
So the second floor is not a common area?
No.
Okay, thank you.
Do we have any other questions from the public? Not seeing a show of hands, I'll close it to the public. Sir?
Yes,
Redirect.
Mr. Halls, just a few questions and redirect. First off, you've reviewed the ordinances in Oradell, and there's no prohibition in the R-4 zone for somebody striping their driveway for a parking space, is there?
I don't believe so.
And in connection with this type of use and your familiarity with group homes that you've worked on, is it appropriate in residential districts when you have such a parking lot to have it striped for location of parking?
It gives a more organized place for the parking. I've done group homes where we do not stripe the parking lots. I've also done it where in most cases, we do stripe them, but I have done group homes where we do not stripe the parking lots.
And in connection with the parking that you're proposing here, the amount of parking you have, you've testified to, more than accommodates the needs as testified to by Mr. Toronto.
Yes, that's correct.
In connection with your not knowing the exact or the size of the homes, you've said this home would be larger than the other ones in the vicinity, correct?
Yes,
And it's recognized that in a neighborhood, one structure is going to be larger than the other. Somebody's going to be the biggest in the neighborhood, correct?
yes,
And what's being proposed here would happen to be the biggest one over whichever one now is the biggest.
that's correct.
Okay, in connection with the height of this building, you testified earlier that, and the architect did too, if I'm correct, that we're not going to the maximum height that's permitted by code.
No, we're below we're not even close. We're several feet several feet lower than what is the maximum permitted.
Do you know what the height of this building is in relationship to other buildings in the neighborhood that could be up to the maximum?
There are several houses, I believe, that are at the maximum.
And what is the maximum?
It's 34 feet,
And this one is somewhat in the vicinity of what?
27 feet,
So at that point, it's like 7 feet less than what the maximum is.
yes.
You testified earlier about from a planning standpoint, the testing that you went through in looking at and evaluating this, and you talked about the inherently beneficial aspects of this, and you cited certain case law, correct?
Yes.
Just like you to reiterate, if you would, your planning testimony and referencing the pertinent case law that's involved, including the Sika case.
Well, in the Sika case, there's 4 steps that the board has to look at when determining the granting of the variance itself. There's 4 steps that are taken in that evaluation. And that's determining whether the proposed use meets the statutory negative criteria. And the first is the public interest of the proposed project. In this case, the project is a group home with the 2 independent units above on the 2nd floor. And it has already been determined that it's acting as the group home, and that in itself is an inherently beneficial use. So in this case, the public interest is the inherently beneficial use of the group home, along with the independent units acting as one complete group home. The second is determining the detrimental effects that would ensue with granting of the variance. And the detrimental effects in this case are granting the D variance for the FAR and exceeding the FAR, and then determining whether that is a significant negative for the proposed use itself, and what the effects are going to be on that on the surrounding property and the streetscape and the municipality as a whole. So the board has to look at in terms of the detrimental effects with that. The third is can anything be done to reduce the impacts from from the use that's proposed? In this case, can you impose reasonable conditions that could be imposed on the use that might affect the granting of the use itself? Can there be something alternate? Could we reduce the size of the parking area? Could we add additional landscaping around there to soften the effects of the impacts? Could we do something else in terms of the site? And other detrimental effects might be stormwater runoff. We have already, in this application, collected the stormwater from both the building and the parking area. Is there something else additionally could be done? Those are all effects that the board should look at when looking at it for potential reasonable conditions that could be placed on the site. And lastly is weigh the positive and negative criteria. In this case, have we met the burden of proof with the application? Is it meeting the intent and purpose of the zone plan, and we meet the intent with the amendment to the zoning plan? We clearly are designing the proposed application in accordance with that amendment. And then is there the negative in terms of we are expanding it in terms of the FAR? Is in this case, the negative impacts of the FAR, we've shown that the proposed house meets the combined side yard setbacks. While there are a variance involved with that, is there something else that could be done in terms of what's the negative impact on the zone plan and zoning ordinance? I believe we've met the burden on that. There's no significant impacts on that, the zone plan and zoning ordinance.
So in looking at this, you have the opinion that in the first prong of this test, that this is, and it's statutorily, that this is an inherently beneficial use, correct?
That is correct. I mean, it's a group home, and clearly it's mentioned in the MLUL that it's permitted in all residential zones. I have experience with doing group homes of this with independent living and a group home. And in the other two communities, I did it, the planning boards also. They were before the planning board, they weren't before the zoning board. And it was determined in both those communities that the independent living along with the group home was considered a group home.
And in connection with the second prong, in terms of the FAR aspect of this area that's there, it's correct, based on the testimony before you testified, from our architect and from Mr. Toronto, that in order to have these units, that are the units that are set forth in the agreements between the Borough of Oradell and this applicant, that this is the minimum area that's required in order to meet the code compliance for a group home for developmentally disabled and for the apartments.
That's correct. That's
There's
what-
no ability here to modify the application. We are at a minimum in connection with what is required.
That is what the architect testified, that's correct.
And in connection with looking at this site and determining that, is there any other conditions that can be imposed to soften the variance being requested, it's our position, and you've testified to, that if there's additional plantings that they would want to see and the board wants to see as a condition, if there's other type of improvements to reduce the look of this aesthetically, by not making it smaller, but on the site itself, that we're amenable to additional landscaping, things like that.
Yes, that's correct.
In connection with the testimony that you've given already, back when you were an engineer, you've testified, correct me if I'm wrong, that the drainage improvements that are being proposed here will not only contain the runoff and meet all of the code requirements, but it's the first time there is any real drainage on this site, and that right now the drainage just sheets off the property. Isn't that correct?
Yes, it just sheets off towards the rear of the property and down towards the river.
And in connection with the surrounding area and in connection with the cemetery aspect, this plan does propose to allow access to the rear of this property for that purpose, correct?
Yes, presently, the only access to the cemetery is through this property, and we're proposing to provide a 15-foot access to continue that access.
That's all I have.
Yeah, thank you. All right. To the professionals and members of the board, you already had the opportunity to question this witness, but we've had redirect, so to the extent of any testimony you've heard tonight, does any member, professional or member of the board have any questions? Okay, there are none. Thank
I
you.
don't know whether counsel or the objector has any recross.
Thank you.
Mr. Halls, are you aware whether the borough's Housing Element and Fair Share Plan 2022 amendment has been approved by the court?
This is beyond the scope of
He's
the
a-
redirect.
He is a planner, though,
But
and
no, the
Mr.
question now was only for you to question him about his redirect testimony.
Okay.
That was not a subject.
Can I explain, though?
Go ahead.
Mr. Whitaker explained that, and Mr. Halls confirmed, that this satisfies the negative criteria. And one of the reasons why it satisfies the negative criteria is because of the borough's agreement with the developer. And that agreement comes from the borough's Housing Element and Fair Share Plan obligations. And so I asked Mr. Halls, because again, he's testifying to you guys, the board, that, this is what satisfies the negative criteria. So I want to know, has this 2022 Housing Element and Fair Share Plan been approved by the court? Because, has it? Do you know, Mr. Halls?
I don't know that.
Ms. Wright, can I ask Ms. Ryder? Maybe she knows?
Caroline, do you know?
He's not a witness in this.
I know she's not a witness. If it's relevant, do you know if it's gone to a court?
I believe I know the answer, but I believe because this round 3 is still under litigation, I don't know
Then
that
do
I
not
should say
answer.
it.
You will
Do you-
not have
do you
an answer.
understand? But that was.
No, I don't understand what you're trying
Okay.
to get at.
If he is going to testify as the planner, that, and he explained the inherently beneficial use. He relied on SECA, he went through all those points with you guys. But then the other component is the negative criteria, which I'm sure you all know, right? Because you guys do this all the time. You have to do variances, you have to do the negative, you have to do the positive. So the negative criteria, the reasons that he provided to the board for why the negative criteria is satisfied under these circumstances. Mr. Hall, am I correct that one of the reasons why this is satisfied under the negative criteria, according to your testimony, is because of this agreement with the developer that stems from the township's housing element fair share plan
He addressed the
2022?
negative criteria. That's what SEEK is all about, at least
No,
I
that,
think.
Masika, I believe, is the positive criteria.
No, it's not. It's the negative.
So the negative criteria in this instance,
Take a look at Cox, page 531,
I
532.
understand, it's a weighing situation.
And it's addressed the negative criteria.
Right,
That's
and-
that's what SEEK is all about.
Correct, and the negative criteria that I believe Mr. Hall's testified to, how it gets satisfied, the things you're weighing, one of the components that you're supposed to weigh, I believe is what he testified, is this agreement with the township that helps fulfill the 2022 Housing Element Fair Share Plan Amendment. So that's why I asked if this had been approved by the court. That's all.
Thank you.
Thank you.
Okay, well,
Mr. Chairman, I'm afforded a couple of other minutes. I just have Mr. Toronto in to just talk about
sure.
this community.
Well, you've got 4 minutes. We might get a little generous, too.
Thank you.
Mr. Toronto's previously been sworn, as everyone knows.
Thank you.
You're sworn in already.
Yep.
Mr. Toronto, you testified previously as being in charge, president, if you will, of Bergen County United Way, and are familiar and hands-on with all of these type of group homes and developmentally disabled housing and buildings that exist throughout the communities, correct?
That is correct.
And again, just for the board's edification, and remember, it's how many years have you been doing this?
We've been building affordable housing for 20-plus years.
And you're involved with all the aspects of the day-to-day operation?
I am.
And you're proposing a group home here with independent living units above, correct?
That is correct.
And is this the first time this is being done, or is there other places where this has occurred?
No, this is repeating a hybrid model that we have built in other communities. Mr. Hall's mentioned many of them. Fair Lawn, Wyckoff, Tenafly, Montvale, proposed in Alpine, Richfield, built in Ridgewood, Hohokus, I can go on and on.
And is this the type of model that is not only prevalent, but also something that is encouraged?
It is, and in fact, this particular style was advocated for, I should say, or reinforced by the governing body because it serves the broadest cross-section of individuals with intellectual and developmental disabilities. By that I mean folks who require 24/7 service support, and then another group or population does not require that level of support. So consequently, making a shared home or group home and providing independent living apartments along with it gives us the broadest reach, so to speak, for folks in Oradell and the surrounding communities who are desirous of this type of housing.
So it's correct to say then this is something that the government body basically requested?
That is correct.
Let's talk about, very briefly, this community room that's now created such a stir. You have community rooms in these other facilities?
We do. It's a hallmark, I would say, of our projects that we include a community room. And there are some instances where we haven't and we regret it. So the purpose of the community room is to really develop and integrate the community that we're building. So in this example, the folks who are in the independent living apartments, as an example, can meet with the folks from the shared home or group home in the community space. Where we don't have a community room, it makes it more difficult because the individuals have to be in the private space of the apartments or in the group home, and that's kind of awkward. Additionally, with the community room, it permits parents and visitors to not necessarily be in the group home space or in the apartment. They can meet in the community room. It's a great spot for the Super Bowl party, for the holiday party, for service organizations, the Scouts, Boy Scouts and Girl Scouts, walking groups to convene and meet. We have regular resident meetings that we use the community room for. So it's really, we view, a pivotal third space that really knits together the community and permits the broader community to also have access to a space that they can meet with the residents as well.
So bottom line, this community room has what's been referred to as common functionality, correct?
That is correct.
And on the basis of that, all of the residents, whether they're upstairs or downstairs, have access to and the ability to use the community room.
That is correct.
And it's your opinion that a community room is a integral part, it's required for a group home, and it's an integral part of making the 2 apartments above function also.
Yeah, we view it as an essential component of what we built.
Thank you.
Okay. 8:35, you've made it on the dot.
Thank you.
Congratulations, thank you. We're going to move on to the next case. Those of you who are going to leave now, please remember, we remain in session, so do so quietly. With that, I will call calendar 882-24, Curalta Health LLC, 680 Kindercamack Road.
Thank you, everyone. Have a nice Thanksgiving.
You too.
Announce a carry date?
Yeah, Mr. Chairman, this is going to be carried to the December meeting.
Oh, I'm sorry, yes.
Yeah, we
This
need
is
to
carried
make
to the
that
December
announcement.
meeting without need
What's
for
the
further
December
notice.
meeting date? Do we know? offhand?
December meeting is December 16th.
December 16th?
December 16th at
This
7:30 p.m.
application for the benefit of the public will be carried to December 16th,
At 7:30 p.m.
7:30, without any further notice. Thanks, Mr. Rebecca.
Good catch, thank you.
So long. Getting out early.
Boy, this emptied out. They don't love you. What can I say?
Beauty to my eyes when they all walk out.
Sure.
I've actually been on where I was just talking with my planner. I've been there. I've been in ones where I have an application that's not contentious. It's a contentious application after me. People sitting there and they've come up and started asking questions.
Yeah.
Like, now I say I'll go at the end. I'll wait. I'll wait. And,
Okay, please proceed.
Mr. Chairman, members of the board, it's nice to see you again. Andrew Kohut, K-O-H-U-T of Wells, Jaworski, and Liebman, 12 Route 17 North in Paramus, New Jersey, on behalf of Curalta Health LLC, 680 Kindercamack Road, Block 807, Lot 2. The board will remember we were here last time to go over the use. There was a very thorough discussion with the board. A lot of conditions were brought up.
You know, that just reminded me that,
Oh, yeah, that's
would
your
you
board
let them know to come
Yeah,
back
we need
in?
the other members.
Thank you.
They wouldn't know that it was under.
Okay, welcome back. Go ahead.
Thank you, Mr. The post-meeting, I had a strategy session with my client. At that time, we were discussing the conditions that were brought up to make sure they were all feasible. And through that discussion, I learned for the first time that the things that he was discussing and the conditions he was agreeing to, he thought pertained to the pain management studies solely, because that requires the overnight component, and that's what the use variance was for. So when he said that to me, I said, well, that's not how this works. So what we did was we sat down, we went through the entire use, what's going to be going on there during the day, which includes other things besides pain management studies, but which are otherwise, I believe, permitted by code. I then said, you know what, I didn't want the board to hear that for the first time tonight. I submitted a letter dated November 11th, 2024, that went over that not only went over the uses during the day, but also went over the conditions that were previously discussed by the board, what I felt were all the conditions, and where we stood on those conditions.
And to pick up on that story, yes, I did receive a copy of that letter.
Okay.
And I ask that you be informed that we don't deal with letters, that you would have to provide testimony.
Absolutely.
And that's where you are today.
Oh, yeah, 100%.
Okay.
I didn't want the board to hear the testimony for the first time tonight. That's all the reason why I did the letter.
Mm-hmm.
Can we mark the letter, though, as an exhibit, as A1?
I'm not inclined on that, Bob.
Okay. Hey, They are occasionally marked in hearings, but it's your call.
If they're occasionally mark it into evidence, but
He's gonna recite the
we
testimony.
are not going to consider it.
I forget what exhibit we're up to.
I think it's A1.
I think you're right.
So I'll call Dr. Gewirtz back to the,
It's your case.
thank you, Mr. Chairman.
And he was previously
he
sworn and
was.
remains under oath.
Okay, doctor. So what I'd like you to go through with the board is during the day, daytime hours, what type of services will you be providing at that time, during the daytime hours?
So during normal daytime business hours, which I'd identify as, say, 8 in the morning till 6 at night, we will be providing clinical trial care, which would and possibly could include applications of grafts for wounds, administration of injections, administration of oral antibiotics or oral medications, observation, use of new equipment to diagnose or possibly treat or manage conditions. We also may be providing medical care, so regular medical care or medical observation or client counseling, medical client counseling for various patients. That would be done during the day. Again, as testified, what would be going on at night during the day.
Before you go to that, what type of medical, give some examples of some medical treatment that is provided by Curalta.
So we're a podiatry group, so all of our care, medical care is provided for the lower extremity. Clinical trials could be involving things ranging from diabetic management to other care during the day. Could be diabetic care, it could be for foot pain and injuries, it could be testing vascular equipment to find out if somebody's, got poor circulation in their legs.
Now, you brought up that you will be doing other studies during the day, correct?
Correct.
However, none of those studies will require the overnight component that we were testified to at last month's meeting, correct?
That is correct. The only studies that require overnight stays are the studies as defined by my previous testimony, which are pain management studies that require overnight observation.
Okay. And during the day, what about staff, number of doctors? What do you foresee during the daytime hours?
Daytime hours will be 1 or 2 physicians, somewhere between 5 and 7 total staff, and other than the 3 people that could be there for the continuation of monitoring, there could be 5 to 7 patients coming between in the waiting room and in the various treatment rooms being taken care of.
And just as we discussed before, these are all scheduled. There's no walk-ins, correct? It's all scheduled appointments?
That's correct. There's no such thing as a walk-in permitted. If somebody was to come to walk into the door, they would be turned away and be forced to make an appointment.
Okay. So, you said, we went over the fact that the only overnight component is for the pain management studies, correct?
That's correct.
Now, we went through, there were several conditions that we discussed, and I just want to go through those conditions again with the board to make sure we've covered everything, then also to let them know the board which of those conditions can apply also to the daytime hours, okay? So the first thing we discussed was private ambulatory service.
These are all set forth in the letter
In the
that
letter,
was
yeah.
marked as A1.
Private ambulatory service, that will be for the entire use, correct?
We have a contract with Rapid Transport, which is an EMS certified by the state ambulance company, and that contract provides 24/7 availability to us.
And they're
What's the name of
located
that company, just so I have it?
Rapid Transport.
Rapid Transit.
Rapid
Mr.
Transport.
Regan, they're in Paramus, located in Paramus, Frisch Court. And that will be there for the normal business hours and for overnight, correct?
Correct.
No walk-ins, we already discussed that, that's for the entire operation, correct?
Correct.
Okay. We discussed no more than 3 overnight participants at a time, that's, again, only for pain management.
That's correct.
Okay. No visitors?
That's correct.
Okay. 3-night stay max?
Can I pause? When we say no visitors, I want to clarify. Visitors means nobody will be coming in to visit anybody who's staying. There could be a rep that shows up or a visitor from another study organization that's
During
coming up
normal business
during
hours.
normal business hours. So I just want to clarify that there will be no walk-in people, patients, but people could visit the location during normal business hours through the course of normal business.
Again, the no medical procedures applies to the overnight studies being done. There will be no medical procedures being done at the overnight.
Correct.
Okay. No charge to participate. That's for that medical. Is that for all studies, or is that just for the pain management studies?
All studies, there's no charge to participate. It's actually illegal to charge a patient to participate.
Okay, and then the last thing we discussed was that we discussed no overnight stays over the weekends, Saturday nights, Sunday nights. And after we went back after the meeting and you discussed that. I know you met with your clinical trial director, and through consultation learned that you would need Saturday night overnights for the pain management. So why don't you just discuss that?
So after having consultation with my clinical trial director and various study sponsors, we determined based on the day and the times that these procedures have to be performed, there's possibilities that we require Saturday night stay so that we can have the trials performed and the procedures performed to do the clinical study of the pain management. So for example, if a procedure is done on a Thursday, that person could have to stay Thursday, Friday, and Saturday night. What we would never have is a Sunday night stay. Everyone would be discharged by Sunday morning, so that there would be no Sunday night involvement.
I have no further questions, Mr. Chairman.
And I just want to apologize to the board for not clarifying this and misunderstanding the testimony I provided last time, applying only to the variance purposes and not to the overall use.
When you get to be perfect, you know, okay. Up until then, don't worry about it. Bob, do you have any questions?
No questions.
Caroline?
So there's no overnight stays on Sundays. What about, I don't know, Memorial Day, national holidays? Are the studies going to be timed so that there won't be overnights on days when typically people aren't working?
That's correct.
Dave?
So Memorial Day weekend, July 4th weekend, Labor Day weekend, Thanksgiving Day weekend, Christmas, New Year's, those holidays.
No overnight stays going into a holiday.
That's what I'm saying, correct.
Gets it, okay.
Thank you. Dave?
No questions.
Steve?
No, Chairman.
Any member of the board have any questions?
There's no variance necessary for any of the daytime activities that you're requesting, it's just simply the
Yeah,
overnight.
I think for two reasons. One, there's, it's professional office is a permitted use in the zone, and then also there's the underlying use variance for a medical facility that in 2007 that already approved this as a medical facility. So I think between those two things and the use variance we're getting for the overnight stay, we're covered.
That's correct. Really, this just involves a request for the elimination of a condition pertaining to overnight stays.
Right.
That's all this is about.
Yeah. Any other member of the board have any questions?
I have a question. If one of the participants has some kind of adverse event that requires medical intervention, is that going to be done off-site? I think you said there's no.
Yeah, so that's why we have an ambulance service.
Yep.
We will be calling them, they will come and transport the patient. We have staff privileges at all the local hospitals, and we'll have that conversation prior to the study, so we'll know where that patient wants to go for care should there be an adverse event.
Okay, perfect, thank you.
Any other member? No. This facility is located on the east side of Kinderkamack Road in an office building, am I correct?
That's correct.
Are there any residences on that side near this office building?
Not that we're aware of.
Do you foresee any disruption to the lifestyle of any borough residents based upon the overnight stay?
I do not.
And if for some reason someone has to come and go, they'll be using Kinderkamack Road or other public streets. Will that cause any disruption to anyone's life here in Oradell?
I don't believe so, since there would be de minimis amount of people coming and going. You're talking one or two cars.
So, seems that what you're asking for is something that will not disrupt anyone who lives in Oradell.
No, my opinion is we're providing a benefit to the people of Oradell by studying this and not causing any disruption to life and happiness in the borough.
No other questions from the board or professionals? I'll open this to the public. Does any member of the public have any questions? State your name and address, please.
Wollerton is 50 Beverly Road. These studies, do they involve any experimental drugs?
Well, when you say experimental, can you clarify?
Well, is it something that I understand it's a drug like for pain, right, you said? Studying pain?
Yes, an example would be, instead of using a narcotic post-operatively, we may be using an anti-inflammatory medication to see if that provides enough pain relief over a 72-hour period to avoid the use of narcotics.
Well, I'm concerned, could there be an adverse effect and cause somebody to hallucinate or anything like that?
Well, no, let me say this, I can't predict that, but we are not trialing any medication that would cause hallucinatory effects. We're using FDA-cleared medications truly for the use of pain management. I don't know what the side effect profile is, which is also why we're studying the medication.
Okay. So these participants, are they going to get paid to participate?
Yes.
And the other thing is, these are from large drug companies are involved in this, like Pfizer and Merck and stuff
Yes.
like that? Yes. How will the distribution of these drugs be carried out as far as who is going to have access to give the patient the drug?
So the only people that can administer the drug are doctors or registered nurses. The drugs are locked up at all times, and only clinical trial staff who's permitted. So there's a registered blinded pharmacist who can unlock and pull out whether it's a drug or whether it's the placebo, and then there's a chain of command to pass the drug to the doctor, and nobody else has access.
Okay, so the drugs will be stored there and on the premises.
The drugs are stored, yes, correct. They're locked up and stored.
Now, as to the amount of the drug, would it be just for that one patient, or will there be drugs for other patients that may come for the same drug? Will you have like a stockpile there?
Well, there's enough to perform the studies, but we're not stockpiling it because there's expirations and there's storage issues. So we may get a shipment once a week of the medication depending on the number of people we have enrolled. Every study is different. I can't answer. These are non-narcotic, non-hallucinogenic, non-heroin type medications. So they're safe and they're permitted to be kept. There's no like FDA or not FDA, like, tobacco, firearm, like, we don't have to clear by having.
Are they
drugs in.
controlled substances?
These are not controlled substances, thank you. That's what I was trying to explain.
So the patients that are in this study, they won't be able to get up and walk out on their own, will they?
Well, we're not, handcuffing them, but no, they can't just leave. I mean, if somebody decides to leave the study in the middle, I can't stop somebody from leaving.
But we don't know what the effect might be if they come and enter the community. That's what I'm wondering.
But they're there's staff that's monitoring to them. So if there's an adverse effect of the medication, then they're going to be taken by ambulance to a hospital. They're not going to be let out into the community. The doors will be locked to the place, so they're not going to be able to just leave. They'd have to verbally say, "I'd like to leave," and then we will make the medical decision if they're safe to leave on their own.
Okay, thank you.
Any other questions? Not seeing a show of hands, I'll close it to the public. Sir,
One more witness.
please.
Thank you.
Would you raise your right hand, please?
I got you.
You swear or affirm that the testimony you will give in this proceeding shall be true, shall be done?
Yes,
And for the record, you give us your full name and spell your last name, please?
certainly. My full name is Christine Nazaro, Nazzaro Cafone. My business address is 125 Half Mile Road, Suite 200, Red Bank, New Jersey, 07701. I'm testifying this evening as a licensed professional planner. I don't believe I've had the pleasure to testify here in the borough previously, but I've been doing this for approximately 28 years. I've been qualified as an expert before.
He's been qualified elsewhere based on my experience.
I've never held
We accept
my-
you as an expert.
Can I just, it's COF or COF?
COF.
Okay,
So
thank you.
one F,
Okay.
F-O-N-E.
Yeah, before you get, it's 8:54. I try to get a break around 9 o'clock, so I don't, if you want to time your questions and that, I don't know how long you expect to.
Let's try and make 9 o'clock.
I'm going to try to make mine direct so that you can take your break.
So, real quick, Ms. Cofone, are you familiar with the application materials?
I am.
Are you familiar with the borough's master plan and zoning ordinances?
I am.
And you're familiar with the property?
Yes, I visited
Okay.
the subject property.
Why don't you go through your planning testimony for the relief being sought?
I will. So the subject property is located in a B2 zone, which permits professional offices, which includes the medical offices. And also, the applicant was given a 2007 approval for a medical center here. So the reason we're here is seeking the modification of the approval and or, to the extent the use variance is required to have up to 3 overnight patients is because the B2 zone and the prior approval didn't allow for the overnight facility. So as such, we have a demonstration to demonstrate to you that the site is particularly suitable for this use, and further, that under the Medici reconciliation, that there is no impairment to the zone plan. So as far as particular suitability, I would say that this site certainly is suitable. Chairman asked a question specifically as to, is this on the eastern side of Kinder-Kamak Road? I would submit that it is on the eastern side of Kinder-Kamak Road, and when you look at the 2018 master plan on page 25, there's a reference there to office buildings and how it reads, and this is not my opinion of it, it reads, the eastern side of Kinder-Kamak Road, north of Oradell Avenue, offers opportunities for larger scale office uses to locate in Oradell. This development pattern is encouraged to continue. However, it is recommended that the borough zoning regulations be enhanced to encourage healthcare uses and medical-related office and research functions, and to require improved site design criteria to ensure an attractive redevelopment if any of the sites in this land use category are to redevelop.
What page is that, just
It's
so I...
page 25, and I may leave this with you if you'd like to have it, but it's simply just a copy of the master plan, and then it just has 2018 written, so I remember the year of the master plan since it's not on that page. So I would submit to the board that it is particularly suitable. In fact, not only is it particularly suitable, but it's quite suitable and consistent with the type of development envisioned in your 2018 master plan. As far as the purposes of the municipal land use law that are advanced by this, statutorily, in order to be granted the use variance, we have to advance one or more. I believe there are 2. Criteria A talks about promoting the general welfare. Last month when we were told together, Doctor testified directly that the reason they're doing this study is to try to reduce dependency on CDS and controlled dangerous substance and narcotics after surgery. So I think that that certainly promotes the general welfare. Criteria G of the land use law talks about providing sufficient space in appropriate locations for a variety of uses. And I do believe that there is sufficient space here. It's an appropriate location. It is zoned for office use and was previously contemplated and found suitable for a surgery, for a medical center.
And I think that's also important for particular suitability, Ms. Cofone, is that the zoning board already saw this property as a more advanced type of medical office facility when they included ambulatory surgery center, urgent care center, imaging center. It was more than just having individual little medical offices.
Correct.
They saw it as being more of a medical center.
Which would also be consistent with the master plan.
Yeah.
So not only was it consistent with the 2007 action by the zoning board, but also consistent with the 2018 master plan. So when those letters that I talked about, A and G, they are not unique to the borough of Oradell. They come right out of section 40:55D-2 of the municipal land use law, and they're identified by purpose. The purposes are identified by letter and not number, and that's how we advance the positive criteria for the purposes of the land use law. Criteria A and G, again, statutorily 1 is sufficient, but I do believe, in my professional planning opinion, those two are both relevant. So that leaves us with a burden proof to reconcile the Medici reconciliation, right? And I love the Medici case. It was a 1986 case decided in 1987. And footnote number 11 in Medici talked about uses that were perhaps unusual and not contemplated at the time of the zoning ordinance. And when that footnote was done back in 87, it talked about things like a gym, which weren't uncommon. Well, that sounds crazy to us today because we know we have a gym in almost every strip mall, but perhaps what wasn't contemplated when the ordinance was done was something like a sleep study where somebody would be wanting to reduce dependency on narcotics. So I think that this is a quintessential textbook Medici case, and I think it was perhaps your master plan in 2018 was pretty forward-thinking, indicating that you wanted to enhance, encourage healthcare and medical-related and office research uses. It just didn't maybe take it to the step of saying overnight sleep centers. So when you balance that, right, because that's what we do when we get to the negative criteria, statutorily, the land use law does not ask you to hold us or any other applicant to a standard that there be no detriment, just that the benefits of the grant of the variance outweigh any detriment, and there's no detrimental impact on the zone plan or the public good. So as far as the public good, I think that this is in a location on the eastern side of Kinderkamic Road, which is zoned for very similar uses. And I think as far as the public good, there is no use around this that I think would be harmed or we would do violence to a zone plan that the borough contemplated. So I believe we meet our statutory burden of proof for the grant of the use variance. We have established the particular suitability as well as the positive and negative criteria and the Medici reconciliation from the B2 zone plan, as well as consistency in furthering your most recent 2018 master plan. So I do believe we meet our statutory burden of proof, and I have nothing further on direct.
Okay. That's it on direct?
We made 9 o'clock.
Okay, well, it is 9 o'clock, 9:01 at this
We
point.
were close.
I'm
We
not,
got
you close at 9. All right, so we will have a little bit of recess for 10 minutes. We will reconvene at 9:11. Restrooms are behind me, and you can stretch wherever you are. Thank you. It's 9:11. We are back in session. Sir?
Mr. Chairman, I have no other witnesses.
No other witness. That makes life easier.
Yeah.
Dave, do you have anything?
I have no questions.
Steve?
Nothing, Chairman.
Caroline?
Nothing, I thought the planner's testimony was very thorough, and to your point, Mr. Chairman, about, you asked a lot of questions about impacting anyone in Oradell, which I thought were really great planning questions.
Thank you.
Just, there's an understanding, of course, that should the board act favorably on the application, this, any type of approval be limited to the space that's in question, and should this be approved and a very successful venture and there's an interest in expansion, there would need to be a return to the board.
Yes,
Yes, I just
understood.
want to make sure
Come
that's
back.
clear, that's very clear.
100%.
Should the board act favorably.
And I would imagine it would be in the resolution.
Yes, that would be a condition.
Okay. Bob, do you
No, I
have
have
any
nothing.
comments? Okay. Does any member of the public have anything they wish to say at the conclusion of this meeting? Not seeing a show of hands, I'll close that. Members of the board, since we're now getting into deliberations, does anybody want to volunteer something, or else I'll just call everybody one at a time to say something? No? Start down there. Do you have anything you'd like to say about this case?
I think it was very thoroughly presented. We understand the benefits, the conditions. I think it's well understood.
Thank you.
I think they presented a very, clear case, that the benefits outweigh any detriment, and very well presented.
Thank you. Sir?
I think, again, the case well presented, and most importantly, that it's a very low traffic or turnover at night, if any, and therefore, well presented.
Sir?
Yeah. Agreed. I think it's a good use of space. No harm.
No harm, no foul.
Thorough testimony. I kind of echo my colleagues there and appreciate the clarification on some of the conditions. It's just helpful.
I think the testimony clearly met the burden of promoting the general welfare. It's essentially an inherently beneficial use, and they clearly met their burden under Medici of the positive outweighing the negative, which appear to be nothing.
Ma'am?
Yep, I agree, and I think you've already shown particular suitability for the site, for the existing use, and it's not that much of an expansion, and echo everything else my colleagues said on the board.
And from my standpoint, I frankly couldn't find a negative in this. Looking, couldn't find it. It's a benefit, not just to Oradell, but frankly to the community as a whole. If you do studies, it's going to benefit everybody. So I see no negatives whatsoever to this, this application. With that, I'll ask for a motion in the affirmative or the negative.
Yep, also move for the board to approve calendar item, is it 882-24, on the grounds that the applicant has met the statutory requirements and demonstrated particular suitability, and that the positives outweigh the negatives.
And I think there was a condition. Bob, is there a condition on?
Well, there'd be a number of conditions. First of all, the conditions detailed in Exhibit A1 would be incorporated into the resolution as well. And also, we have a condition that it would not be expanded beyond the use of this portion of the building that the applicant
So
utilized.
you accept those conditions as part of your resolution?
Yep, subject to those stated conditions.
Okay, thank you. All right, do we have a second?
Second.
We have a second. We have a motion and a second.
This should, only 7 people should vote. I know 8 members are present, but one alternate is present.
Okay, let's see, who is, Ms. Day is not, is the second alternate, so you will not be voting. But you can tell us how you think anyway. All right, with that, Mr. Barrows,
Yes.
Mr. Bartlett,
Yes.
Mr. Devine,
Yes.
Ms. Zadinsky,
Yes.
Mr. Santaniello,
Yes.
Mrs. Cobb,
Yes.
and Mr. Michaelman, yes. So the application is approved. What happens next is this will be reduced to writing, which will be presented to the board at the next meeting. We will then vote on that, and obviously I don't anticipate any problems approving that resolution. Then members of the public have 45 days within which to object to this. So please don't do anything for 45 days after the time we adopt the resolution. With that, thank you very much. Happy Thanksgiving, Merry Christmas.
Same to you,
Thank you.
members of the board. We appreciate your time. Thank you.
No, you gave me the page. I have it in my office. That's fine.
All right.
Yeah, I'm
And
fine.
with
Thank
that,
you.
I will call calendar 883-24, Soroya Realty LLC, 420 Kinnicamack Road. Folks, you want to come in? I feel like Bob Barker, come on down, you know. And you will still have 1 hour. I don't know if you'll need it, but you'll have it. We make it out before 11 o'clock after all.
Go back, sign up for that clinical trial, right?
Yeah.
Usually about there.
if you would proceed.
Mr. Costa, are you ready? Good evening, Chair, members of the board. My name is Santo Alampi. I am an attorney still, and I represent the applicant. This is the continuation of the 420 Kinderkamak Road application. We were here back in October, as the board is aware, and we had left off. Mr. Costa was providing testimony, and at the time, Mr. Atkinson had issued a letter with a date of, I believe it was October 15th, if I'm not mistaken. And at the time, the team had not had the opportunity to review that letter, so that is where Mr. Costa had suspended his testimony. I'd be remiss if I didn't mention that we did receive a planning memorandum Friday evening, and we have received that. So that memorandum is from the board planner. It is dated November 15th, and the applicant is in receipt of that. I don't know that we get to planning testimony this evening, but we do have that review letter as well.
Well, Mr. Atkinson's report of October 15th has never been marked, to my knowledge. Now, if you're going to be referring to, we should note that that's B1, I guess, first board exhibit.
You said B1, Mr. Regan?
B1.
Should we mark the TNM report as B2 while we're marking?
We
or-
can, but as you indicated, we probably unlikely we'll get that far, but we can mark it just if in case there's any reference.
All right. So I have B1 as the Neglia October 15th letter.
E&M would be B2. Okay.
Okay, thank you. So with that, Mr. Costa.
Chairman, good evening, members of the board, good evening, the public.
If you would use, if you're going to extend the microphone,
All right, thank you.
Sam, let us know if it's picking up the sound.
Can you hear me?
Yeah, okay.
Perfect, thank you. Mr. Chairman, as you heard Mr. Lampe say earlier, so at the last meeting, for whatever reason, we were never given a copy of the October 15th letter. It was given to us the next day. I think it went to Mr. Lampe and then to my office. And since then, my staff and myself has been going through it very closely. Tonight, if I can, we can either go through it very closely, because what I tried to do, and basically the crux of the issue with the letter, if I can get the board's attention to, I believe it's page 5. And that would be under section 4.2. I'm not sure if we could put it up on the screen or not.
Page?
It would be page 5 of 12. And again, that's on the Neglia review letter. It's dated October 15th, 2024.
I think you just went past it. No, that's not this.
It's authored by David R. Atkinson. And again, it's section number 4. Just for the record, grading, drainage, grading, and utility comments. And it's section 4.2.
So, Mr. Costa, what we're going to be discussing is whether or not the project is qualified or classified as a major development.
That's correct.
And again, this is with respect to stormwater management and the new administrative code.
That is correct. So, two things that came out. So basically, in July of last year, the DEP changed the requirements for drainage in our state, under the new stormwater management. Every community in New Jersey had 1 year to adopt those rules and regulations. Actually, I believe
Oradell adopted them in August of this year. So a little bit late, but again, no harm, no foul, because I don't think the DEP is going to fine you. With that, Mr.
Mr.
Atkins.
Costa, for purposes of the record, I have to point out, I don't know that it's been adopted. Obviously, there's a process that has to go through. I believe it was presented by ordinance to the mayor and council, and there was a second reading of that. I don't know that it's been codified, don't know that the county has signed off. But that ordinance, in effect, attempts to capture the DEP regulation. Is that your understanding?
That's correct.
Okay.
So with that, again, with the letter that was, again, authored and dated October 15th, section 4.2, and I'll read it aloud. The proposed improvements classify the project as a major development as defined under the Stormwater Management Adopted New Rule NJAC 78 by disturbing more than 1 acre. So it seems innocuous, it seems no big deal. But in actuality, it is somewhat of a big deal, whether or not our plan would comply with those rules or not, and whether or not our plan has to comply with those rules. So since the last meeting, we've gone through the actual reading of the rules, the definitions from DEP, and again, for the record, the property is not within the 100-year floodplain, so the NJDEP actually has no jurisdiction in this case. It's not within the 100-year floodplain. There's no wetlands on the property. So in essence, they are outside of their jurisdiction, so the jurisdiction would fall here within the borough of Oradell, and obviously because Kindercamack Road is a county road, the county of Bergen. With that, we created a map and an exhibit, and I can certainly mark this.
Mr. Costa, before we do that, do you have the original exhibit that was submitted with the application package by chance?
This would be the original, yes.
And what is that exhibit referred to as?
If the color rendering was marked previously at the last meeting? That's correct.
A3, I think. Sheet 2 of 14.
Let me just put that up. That is correct.
This is,
That's the sheet 6.
yeah, this is it.
It's going to put up sheet 6.
Sheet 6?
Yes.
Don't forget the microphone.
Sorry. Thank you, Chairman.
Yes?
I believe that's sheet 6 up on the screen.
Yes. That sheet, I'm sorry, sheet 4, so sheet 6 would be the soil erosion plan.
And that's what's up on the screen?
Sheet 4, this would be the plan right here.
Oh, that was?
That's it, yes.
That's 6. This is 6.
Sheet 6.
You want
Yes.
4?
No. No, sheet 6. Correct? You said the soil erosion plan?
Yeah,
Yes.
that's what's up on the screen.
Correct.
Okay. So, Mr. Costa, your office prepared this exhibit?
Yes, we did.
This exhibit was submitted with the original drawings, the engineering drawings last revised?
Yes.
Okay. And Mr. Costa, what does this sheet show that matters particular to this testimony and the question regarding major development?
So again, for the record, so in the soil erosion plan, we called the area disturbance 39,710.23 square feet. That is the size of the lot And basically, if you go there today with the Bank of America building, with the driveways that exist, in order to create the proposal that we have before you guys this evening, you would have to remove basically the entire lot and disturb the entire lot. I could hand out some photos of the site if that's helpful to everybody, aerial views, so you would see it if you'd like that, or
It's up to you whether you want to present it.
Mr. Costa, we're going to mark those as A4 when you get to them. Is it one photo, Mr. Costa, or is it a set of photos?
it's one photo of the site.
That's going to be A4.
And just tell us what it is.
Thank you.
It's an aerial photo of the current site. I believe it's off of Google Maps. It's either Google or Bing Maps.
Mr. Costa, that photo is an accurate representation of what's out there today?
Yes. So in essence, you have obviously the Bank of America building, you have a couple of trees in the middle of the site, you have driveways, you have 3 driveway cuts coming off the street. You have the, excuse me, you have the drive-through that circumnavigates the entire perimeter of the lot, coming in at the easterly side, circumnavigating around in order to go through the drive-throughs, and then you got the internal parking in and out there, and then the exit only coming out onto the intersection close to Kinderkamak Road. What this shows is basically, in order to create the proposal, we're removing all of the pavement, all of the curbing, all of that impervious area, and then actually recreating this with the building, with the new parking area, and actually adding more green than presently is there today.
Within the boundary of the site, is that
In
accurate?
the boundary of the site, correct.
So when you say you're removing curbing, you're talking about internal curbing to the site?
Correct.
Okay.
As we move, excuse me, closer to that, there was a question, we looked at the intersection, the handicap ramps, they actually, the one on the corner of Beldrin and Kinderkamak actually is not up to code. So we actually are showing that as to be removed and to replaced. There was a question earlier on the report, and I think it was here in public, that the architect showed a few doors towards the south of the existing building. We actually looked at that. We can modify that and actually make this a little bit smaller, the entry that we showed, and we're actually having 3 separate cuts to come into the building itself to go to the stores. By doing so, and removing an internal walkway in this location, that's how we came up with this exhibit, which we'll mark A4, I guess.
We'd be up to
What are we
A5,
calling
Mr.
this?
Costa. But Mr. Costa,
That's
before we
A5.
go to what you've now put up as A5, can you just talk about, I guess, under the regulation, is it your understanding as to what determines whether or not you meet the threshold of a major development?
I don't believe we meet the threshold of a major development.
But is there something that actually dictates what a major development is? Is it 5 square feet? Is it 30 square feet? Is it
It's 43,560 square feet of disturbance.
an acre?
1 acre, correct.
Okay, but our site is under an acre.
That is correct.
So how do you reconcile that?
So I took it a step further. And again, in my opinion, I don't believe the area outside of our property would come into this. But if it does, on this plan itself, we're showing the area disturbance of the lot, the area of the sidewalk disturbance, so the entire sidewalk perimeter, plus the the sanitary sewer. If we need to replace the sanitary sewer, obviously we'll TV it. We'll make sure it's in good condition. If it's large enough to handle the new development, obviously we wouldn't have to go into the roadway. If it's too small and we have to upsize it, change it, for whatever reason, we've added that disturbance in. And then if we have to replace the curb
It's a new exhibit.
around the perimeter,
New exhibit.
we would also do that. And by doing so, if you added up all of those numbers, we come close, but it's 43,192.52 square feet, or 0.99 acres. But again, just for the record, there's nothing that I found in 7:8. We contacted the DEP, sent an email to Dennis Contoy. First response was,
Mr. Costa, who's Dennis Contoy?
he is in the land use section. He's one of the managers in land use. I know Dennis for probably 20 years
So
or
let's
more.
just back up one step, Mr. Costa. Mr. Costa, you are the borough engineer in River Edge, is that accurate?
That's accurate.
And you've been there for quite some time. no?
I have.
And you may have served as a board engineer or borough engineer elsewhere within the state of New Jersey.
Currently in Englewood, city of Englewood, Pagoda, yes.
So
Prior, Saddlebrook, and numerous places.
in both your private practice as well as your municipal practice, you have gotten familiar with some of the personnel down at the Department of Environmental Protection.
Absolutely.
And one of those people is this gentleman, Dennis, that you just mentioned.
That is correct.
So as a result of the new regulation, you've made your own interpretations of those regulations since July of 2023?
Yes.
And you've been providing a professional
Any
opinion with
plan
regard
that
to
comes
those?
before any of the boards that we represent, we keep everything on the site itself. In my opinion, I think that's correct. Recently, in the Subaru dealership in Englewood, Boswell Engineering was the engineer that presented the case. And again, we went back and forth, should it be, shouldn't it be? His argument was, we're on site. Ultimately, I said, I think you're correct. Recently, a job that we had in Hackensack, where the Neglier office reviewed that plan on 952 Main Street, all of disturbance was kept on site, even though some of the disturbance we did to the sidewalk, to the sewer was off-site. But again, we didn't include that in our area disturbance.
So, Mr. Costa, when you got and were able to review the October 15th letter, one of the things that you did after going through the regulations, based on what your understanding was you actually reached out to the DEP.
That is correct.
And this gentleman, again, is who?
Dennis Contoy?
Who is he at the DEP?
He's a manager of land use in our area in Bergen County.
Could you give me the spelling of the last name?
I think it's Contois.
That's right. That's correct.
So you had a conversation with him regarding this specific
Just
issue?
email, just email back and forth. Did
Okay.
not have a conversation.
And please tell us what the,
Basically said, even if you replace in kind, so in this case, if the sidewalk comes out, new sidewalk goes in, it's not going to trigger any green measures. If you add the utilities and you add it in, again, not going to add because there's a road there now. And if you go into the regulations, if you mill or pave, doesn't count. It's not counted towards, so obviously if the town mills and paves a street and they're paving acres of street, it's not going to jump into a major development where now the town has to now put in green measures, stormwater management measures, all the above. It's exempt. If you go to frequently asked questions, it talks about temporary, which in this case would be considered temporary because you're opening up a street, putting in the sewer, closing the street, and I think that's where it falls back in, and I think that's, again, it's not specific in it, in 7.8. I don't think it's been litigated to date, but again, my opinion, it would then fall so far out the lines that if you did anything that goes over an acre, whether it's the town, whether it's a private individual, in a street that exists, you would then have to put in stormwater management for the whole town. So I would imagine that that's probably why that exemption exists and they put that in there.
so Mr. Costa, specifically with respect to our site, the site is less than an acre, correct?
Correct.
But if you accept the premise that perhaps disturbance outside of the boundary of the site were to count towards major development, the exhibit that you're showing is a calculation that results in the area of disturbance being under an acre? Is that what that exhibit demonstrates?
Yes.
And that takes into consideration both sidewalks and curbing as testified.
Correct. And certainly will provide DWG drawings to Mr. Atkinson and to, obviously, to Carolyn.
So, Mr. Costa, I know that we did not submit that exhibit prior to this evening, mostly due to the fact that you were working on it up and until you printed it and ran it here this evening, so.
Correct.
We've marked it as A5. Does it have a title on it?
Again, we still call it the Soil Erosion Sediment Control Plan. That's what we put this on. And the only reason, if this is accepted in the future, this is what we will submit to soil erosion because obviously they require a limited disturbance on those plans as well.
And you'll send a PDF to,
No, a DWG. This way they can check our calculations to make sure they're correct.
Okay, Mr. Costa, so I believe that addresses the major development comment in the Neglia letter, which I believe is pretty much all, well,
Well, it's not all.
it's 4.2.
It's basically 4.2, but the other stuff that's in here,
I want to go through it point by point for purposes of the record. I know it's a little belaboring, but I think it's important because you may have to make some other revisions. I'd like for you to tell us whether you can comply or not and what other issues you may have.
absolutely. So again, page 1 would just be obviously what documents were looked at and reviewed. Page 2, is the same thing, the application of what was presented and reviewed. There's a project description, and then there's variance and waivers, which Neglia has now deferred to the board planner. We received again her planning report on Friday night. It goes into general comments. This time, schedule a hearing regarding the matter, representative of the owner. Obviously, the owner is present. The applicant shall provide testimony that there's no existing title restrictions. I pulled copies of the deeds, which I will certainly give to your board attorney.
A6.
A6.
Your board planner. Mr. Chairman, I have an extra set for yourself, if you'd like it. I'll have everything on PDF. And the engineer.
Thank you.
Pass this down to Steve.
thank you.
Excuse me, the applicant's professional shall provide testimony related to the variances. Obviously, you heard me at the first meeting. We have a planner. If there's anything damaged, we'll put a note on the plan. Very simple, we did already. As far as off-street parking, hours of operation, number of employees, so on and so forth, Bill Page is here that will be doing traffic. We'd address anything from the fire department and the police department. To date, I have not received any letters from either of those entities. I don't know if you did, Mr. Lampley?
Nothing yet.
I have not yet.
If anything's damaged, again, during construction, anything, obviously, my client would have to fix it, and we put a note on the plan. A note on the plan saying any demolition, construction, material disposal shall be disposed in accordance with the regulations. Of course, they will.
Mr. Costa, you say that you've put notes on the plan. Obviously, this letter from Mr. Atkinson is dated October 15th.
Correct.
The notes that you're referring to, have you been revising the plans but not yet submitted those plans?
That is correct.
So you anticipate submitting revised plans
The
to
only, and again,
address those comments?
no sleight of hand until, I guess, we get an answer on this, because this will change the plan possibly dramatically. Obviously, the notes aren't going to change, so we've made those changes already. A note on the plan that the entire works may be maintained in a safe manner, obviously, of course. As far as material boards, the architect is probably up next after my testimony, so I'm sure he's going to provide what the materials are going to be for the proposed building. Provide a legend under number 3, engineering comments. we can certainly provide a legend. I don't think that's any big deal. I actually went through your checklist, went through your ordinances. There's actually no requirement for a legend, but certainly we take no exception to putting a legend on the plan. Per the ordinance, no more than 10 parking spaces in a row. And I think Carolyn brought this up at the last meeting. There is actually a section in your ordinance.
Seven.
What is that, Mr. Costa?
It's the off-street parking requirements.
Out of the Borough Code? Code section identified on that sheet?
240-6.6 off-street parking.
Thank you.
So basically what that says is that 30% of your parking can be compact parking, which would be 8 by 16. In this case, if you wanted us to do it, we could make those parking spaces, they're 9 by 18, we wouldn't restrict the 16, but we can, per your ordinance, if you wanted to reduce the amount of impervious a little bit more. But by making them 8 foot wide, we could pick those up in the area that's open to the air, and then we would put in the 5 foot landscape section in there. So,
Mr. Costa, if I understand what you're saying is you've designed the parking layout to maximize the parking, is that correct?
correct.
And as a result of maximizing the parking in terms of giving full complying parking spaces, you did not include the, I'll refer to them as islands, in between every 10 spaces as required by section 246.6A9. Is that
Correct.
what you did? But under the other section of the ordinance that you just marked as A7, 30% of the parking is allowed to be compact spots, and if you were to utilize that section of the ordinance, you could put the compact spots in and therefore add back the islands in between the 10 spaces. Is that correct?
Correct.
And therefore, we don't lose any parking, but now we've got the required islands, and instead of full-size spaces, we've added compact spaces in compliance with the ordinance, correct?
Actually, again, the ordinance allows for 30%. We probably would only need half of that number because we would have 5 spaces. You got to pick up 5 feet. So you'd lose 5 spaces. They're 9 foot, 5 times 1, 5 feet, and then that would add it back. So you'd have 10 spaces that would be compact. And again, based on 75, I believe it's 22 parking spaces you'd be allowed under your ordinance for compact.
Understood. On the demolition plan, existing flagpole,
The existing flagpole, it's in the front along Veldran. The idea is to keep it there. We might have to take it out and then put it back in, but the idea was to to actually keep it and put it back in. If it gets damaged, obviously we'd have to replace it, but the idea is to actually, you can actually almost keep it where it is, and it probably shouldn't get damaged during construction. But again, if it has to be removed, the idea is to then at least put it back in and replace it there. It's been there a long time. I think it's a nice look in the front of the building.
so we're trying to maintain it.
Either way, either replace it, if it gets damaged, keep it there during construction, and again, if it, worst case scenario, replace it in kind.
Put the spot bump in, obviously. You talked about the access to the proposed doorways, which is 3.6 of the letter.
Correct.
And add the north arrow.
Correct.
Proposed generators on site?
We testified at the last meeting, there is no generator proposed. I don't know if that's changed.
Did you look at the 3.9 comment regarding the scaling on the plans?
We fixed that already.
Okay. 3.10 talks about the limit of disturbance on the soil erosion plan. I believe you just went through that in detail.
Yes.
And 3.11,
Yes. The trees are being, obviously, they have to be removed. And we have to meet the ordinance requirements on the replacement, which your planner brought up, which we will adhere to.
Can you speak to 3.13, environmental impacts of the proposed improvements?
Before we go there, 3.12, the minimum is 4,000 pound. We normally spec 4,500 pound. We use fibercrete on our improvements. It seems to be working. The only thing you got to do is make sure you seal it, because for whatever reason, if you don't seal it with the salt, with the winter, it's a problem. But we've been using it in River Ridge quite often, and any of the private jobs, any of the town jobs, municipal jobs, county jobs, we've been using that.
Does it have to be sealed seasonally, or?
No. You
Just
can do
one
it,
time?
there's stuff you can do the minute you pour it, or you can use a Sika product. You wait 30 days, the Sika product, till it cures 28 days. But either one work. We have both specs. We'll certainly provide both specs to you. Because what irks me, when you put in a new sidewalk and the next thing you know, the whole surface is flaking apart for no reason. Next.
I skipped that one because it said you comply.
Environmental impacts, I think that came up. Again, if you want us to provide an environmental impact report, we certainly will. I think what I testified at the last meeting, we're taking out more impervious than we're putting back in. Certainly, we have a bank building that's gone, no longer there. So this would be an adaptive reuse of the property. I don't want to harp on this because I have other experts behind me that can certainly tell you a better story than me. But if you want us to submit one, we certainly will. I don't see any negative impacts whatsoever from this. I think the attraction of the building, I think the landscaping around it, I think the inclusion, again, that we are adding detention to this site, so we are providing less runoff than what exists today. We're actually decreasing the runoff. All of
Mr.
the
Costa,
above.
just talk about that very, very briefly, because I know the issue of major development and the regs is at least in question, I guess. We're proposing stormwater management, obviously.
course.
It's not as if we're not proposing anything, correct?
Correct.
And you've submitted calculations and you've designed a detention system.
Correct.
What's currently at the site? Do you know?
There is no stormwater management. Everything goes into the municipal system, undetained.
How does it get into the municipal system?
There's a series of inlets on the property itself that tie in. The storm drain actually runs down the center of the sidewalk. It heads easterly through the municipal parking lot and then ultimately discharges into the Hackensack River. South of, obviously, the reservoir, so you're still within fluvial flow. The tide stops roughly just south of River Edge, pretty much by the old Newbridge Bridge down there.
So all of the on-site impervious coverage existing is being funneled into the municipal storm system unchecked? Is that
Correct.
accurate?
Correct.
Doesn't sound good. What are you proposing? You're proposing detention?
Yes. Yes. And again, there's another section of the not the ordinance, but 7-8. If you add more than 1 acre of new motor vehicle storage, that also triggers a higher regulation. We certainly are not even close to that. So we don't trigger any of that. And again, you have more motor vehicle storage today than you will have in the future.
And I suspect that matters because of oils and pollutants
Correct.
from automobiles?
Correct. Even though I'm not sure what happens as time goes on and everything's electric. I don't know how that really works. But
Is that it for the threes?
certainly, we're going to submit a foundation location to make sure that the building, if this board graciously approves it, it gets built in the right location. And then obviously at the end, the final as-built. Again, for the record, I'll submit all the DWG drawings to your planner, to your engineer, that they can check our calculations and whether they agree with them or not. As far as number 5 would be traffic, again, that would be Mr. Page. Number 6, soil moving comments, we'll certainly provide all of that. Anything to do with landscaping, we've actually been able, by modifying the front of the building, the sidewalk, we can actually add more landscaping and make that a more attractive look. I think there was a question on lighting. I went out there this evening. There's actually a
6.
pole at the intersection of
Page
Hendrick
6?
Mac.
No, no.
You're not giving us verse, chapter, where you are, so we're trying to follow you. Number 6 is soil movement comments. That's on page 9.
Correct.
Okay, so that was the question.
We will provide.
Timken's trying to keep up, and you're turning your back and
We will
moving.
provide, we will certainly provide the calculations for soil movement. Obviously, we'd have to dig out a portion of the basement area because this is below grade. We'll provide everything to the board prior to, obviously, this hearing is going to be over tonight, provided to your engineer, to your planner, so we have no problem with that. Again, section 5 was traffic. That gentleman is in back of me coming up after. Landscaping, again, landscaping and lighting,
7, paragraph 7, page 10.
correct. We designed a lighting plan, again, from the back to the front. We don't have lights along the streetscape in the front. So the thought is, your streetscape actually ends south of here. All of the streetscape doesn't go down the side streets. But I guess the question becomes whether or not, in this area, do you want it here? You don't want it here. And I'm not sure, Mr. Chairman or the board, whether or not the streetscape is moving further north, whether you don't want an intersection, I'm not sure. If you don't want it here, to give some light along the walkway in the front, maybe bollards, to put in some low bollards, or some decorative lighting in the front of the proposal there, even put it on site. But again, it's certainly up to you, or I'll work with your professionals. However, you guys make a decision on that.
Let me just say, you tell us what you want to do, and then we'll decide if we think there should be anything additional or we don't like it.
Okay. All right, that's fine. I'm just saying, I don't know if there's a master plan as far as that area in Oradell. I don't know. So I certainly don't want to do anything that this board doesn't want, but certainly we can come up with stuff. We'll give a couple of different ideas if you want that. Not a problem.
Currently, we're not proposing any streetscape lighting improvements. Is that?
Not on, right, as of today, we are not.
Thank you, Mr. Costa. We will submit the tree removal to Shade Tree, I believe.
Absolutely.
We put in for a permit. I'll have to double check that, but I believe we did.
I think that's it.
Mr. Chairman, I have no further questions for Mr. Costa.
Thank you. Caroline, do you have any questions?
I don't have any questions at this time, thank you.
Dave?
He's provided testimony on the questions that we had, just for the board's knowledge. Really, the big question we had was related to whether or not it's considered an acre of disturbance or greater, or if it's less than. So, assuming that the calculations that are here bring it under an acre of disturbance, then this is not a major development. If it is over that, then it would be considered a major development. As the site is a residential property, the RSIS requirements would govern for a major development in this scenario, which would trigger the state's regulations for it. However, as testified, it's under an acre, so What I would ask, if you could just provide the documentation between yourself and the DEP, so we have that for the record. That's really the main stuff that I have from this evening.
Steve?
The only thing I have is that all documents be submitted to the land use board. PDFs, CADs, whatever.
If it's okay, I think the best thing is to provide the DWG. If everybody's in agreement with that, then we'll modify our plan based on the notes. They're on there. I'll submit everything to the board so that it keeps the record very clear. And then we'll do a strip in the front, and try, maybe even do a rendering if we can, just to give you some ideas what this is gonna look like, and give it to our landscape architect to make it, so you guys get a visual of what that could be.
Anything else, Steve?
None, John.
Would you give them your thoughts on lighting and the like, and then that can be presented to us so we can consider whether we want anything more or whatever?
My thoughts on the lighting?
Yes, because they were talking about possible lighting and asking the board for input. And frankly, I'm loath to provide comments on something until I hear what they're proposing.
I would say the same. Let's see what they're proposing. I
Okay.
mean, he's correct, it's not part of that downtown project for the lighting and sidewalk and so forth, but it might be a nice presentation if that's submitted, at that time.
What I think, I'll do a few,
Okay.
and then.
And tell us what you,
Maybe you'll like it, maybe you'll hate it.
and tell us what you want to propose.
Fair enough.
Okay, give us a choice, but whatever. And it's your
The key is
case.
this. Obviously, aesthetics are very important.
Yes.
Extremely important. The building, if it's approved, you need something that looks obviously very attractive in this area. This is a high volume, high traffic center of town. Lighting is very important. And again, if you want to do uplighting on the building itself, I'd go back to this gentleman.
Yeah.
You can do a lot of different things, and I think the opportunity presents itself on this site. The bank is gone, put a building there that's going to make this a monument in the center of your community. And you have an opportunity here.
Mr. Chairman, this is where Mr. Costa wants to talk about architecture, because we all know the architecture is more beautiful.
important.
Talking
Chairman,
about curbs.
It's
There was a
important.
presentation prior, when the bank wanted to do lighting,
Yeah.
and there was street lighting that they proposed. So it was-
Thank you.
And Chairman, I would say, being that you're gonna have some storefronts here and people walking, obviously along the streets, it would be beneficial to have some sort of lighting. However, it's handled by the
Yeah.
applicant.
Again, my thoughts also, but I'd like to hear what's being proposed before I start interposing anything else.
Okay.
Bob, do you have any?
No questions.
Okay.
Your wish is my command, Chairman.
You wanna
You
talk
shall
to-
do so.
You want to talk to my wife?
Thank you again.
All right, thank you. Hey, hold on, any member of the board have any questions?
Yeah, I just had on, I forget which one it was, about, 2.2. You pulled the deeds, did somebody pull title, just to see if there's any easements or CCNRs or anything?
So we looked at the deeds does not, the deed does not reflect any restrictions. Title obviously was clear when the property was purchased. I did not handle the purchase, but as I understand it, we submitted a representation that there were no easements of record,
Okay, that was.
but
We'll provide the schedule.
No, and on the whole testimony with the major disturbance, that just, during the testimony, it cried out to me for, that should have been stipulation. We wasted 45 minutes on that. No, honestly, that,
I don't interfere with their case. All right, any other questions?
no.
Any other member?
I have a question, yeah.
Please.
What, in this zone, what are the permitted commercial uses for the storefronts?
I think there's various permitted uses, and we wouldn't propose anything in those storefronts that aren't permitted in those storefronts.
So
We're
you're not
proposing
asking for anything outside of the permitted use?
Correct. We're not proposing specific uses, obviously, other than the commercial space, which is required by the ordinance that there be commercial space. So we don't have any prospective tenants of that space as of yet. Our anticipation is that we would fill that space with permitted uses. If, for whatever reason, we found a use that wanted to be in the space that isn't permitted, we'd be back to the board seeking relief to put that tenant in. I think it's general business uses,
Retail, mercantile.
retail, mercantile.
Retail, professional offices,
Actually, it's also on page 5 of my report. I list out all the
Okay.
permitted uses, but it's pretty general retail, office, also dancing instructional studios.
Would a brew pub like Five and Dimes in Emerson?
I'm sorry, I didn't hear what you said.
Would a brew pub like Five and Dimes in Emerson qualify?
Like a brewery, is what
Yeah.
you're saying.
That's more food handling, it would need to be approved. It's, restaurants are conditional uses.
Restaurants are conditional. And I don't even know that this would necessarily qualify as a restaurant. I think that municipalities that have wanted to move forward with something like similar to the Five Dimes would would amend their ordinance to permit a brewery.
They have a special type of permit. They can't serve food. They bring it in.
They bring it in.
Yeah.
Right,
I think it's a brewery, which I think
Yeah.
winds up in a different category
right, it's
than a restaurant.
not like a restaurant.
That it counts towards the town.
And I don't believe breweries are
No.
identified anywhere in
I
the
don't-
Or Delaware.
Right, I don't believe that that would be permitted. I don't believe that would be a permitted use with respect to the zone district.
Not the way the ordinance is
Not the way the ordinance is written. In fact, I don't believe it would be permitted anywhere in the municipality, but of course, that's not the question.
Right. Do we have any other questions from the board? Okay, then I'll open it to the public. Does any member of the public have questions? State your name and address, please.
Paul Atsunas, 50 Beverly Road. Two questions. On the infrastructure, are you going to pay for all the infrastructure that's needed for this project?
when you say pave.
Hey,
Pay,
Pay.
Oh, pay.
Yeah,
I would think so, yes.
you are going, the sewage and all,
Personally, but it's generally.
yeah, the sewage and, that you described and.
Of course.
All right. On the retention area, you noted and said, and caught my eye about the EPA, that the water that goes down there now, it's not being cleaned and going right into the Hackensack River,
Correct.
right? So what did you propose with this retention? How is that going to change?
I'm sorry, how is?
Is that going to change, or are you going to be able to clean it before it goes in there?
Well, it all depends.
What are you
Right
going to
now-
do?
Right now, we're not proposing to clean the water, we're proposing to capture it and then slowly outlet it into the system.
So it's the same water that's going in there now is still going to be going in
Well,
there?
not necessarily, because you're gonna have, what you have here is obviously a mixed use, residential, commercial. Right now, you have commercial. And again, I don't want to take the thunder away from Mr. Page. But basically, you're gonna have underground parking also, which isn't going to go to that level because you're not gonna have the rain running down there. If you have any spills or anything in that area, you would then obviously clean it, and you'd have a plan to do so, which you would up here also.
So you would clean the parking lot? I mean, you would spray
I'm
water
saying
and
if something
clean it?
happened, if a gas tank failed, something, there would be, obviously, you have to put a plan together so that just doesn't go haphazardly into the municipal system and into the river.
Mr. Costa, you did testify that there was a reduction.
Into the mic, please.
There you go.
Mr. Costa, you did testify that there was a reduction in motor vehicle on site.
Yes. Yes.
Okay, so there's no way of filtering it out or anything like that?
You
Before
can
it goes-
filter it out, yes,
You can?
absolutely.
And that's going to be done in the retention area?
Say he's gonna do it. He said it's physically-
You're asking me, can you? You absolutely can.
Yeah, will you?
You have to ask my client if he's willing to put a system in, but you can certainly clean it, yes.
Okay, because there might be accidents and spillovers in the
Again,
parking lots?
you need to have a plan intact to make sure, an SSP plan, to make sure that you have provisions for that.
Okay, thank you so much.
You're welcome.
Okay, that, I guess we'll move on to the next one.
Chairman, can I just ask one
please,
question?
Please.
Mr. Costa, as far as, I think he's talking about a water quality structure.
Yes.
Are you required to, if this is considered not a major development, are you required to put in a water quality system?
It's a good question. I don't think we have to because we don't hit the mark of an acre of new motor vehicle surface area, so I don't think you do. There are other provisions that we can do, certainly, to pick up if you want TSS removal, which we could probably do so. Here's the thing. A lot of the new regulations are green measures, which are fabulous, but they need to be maintained over time. They really have to be maintained, and if they're not, it's self-defeating. And that's why the DEP puts the onus on the community. Your town engineer has to go out and police it, and then you have to get private individuals to do it. And basically DEP says, go do it, and now you provide the resources to go get it done. And that's the issue. And now if these measures are harder to maintain, who actually maintains them? And that's what I'm saying in the future. And then the question becomes, if this site is the one to put these measures in the scheme of everything, in the borough of Oradell, what impact is that really going to have on flooding in the Hackensack River Basin? And what water quality is that site going to have to water quality in that basin? It's de minimis. We'd have to live 1,000 years for these regulations to have any effect, I think, on any community. And I think that's where our senators have to get involved, our assemblymen, because as time goes on, we're all part of it. New Milford Avenue, Oradell Avenue, River Edge Road, South End by Hackensack Avenue. Our whole place, the storms that we've had recently inundate our area and paralyze our area. And by doing this and saying, go build this new project and put 30% more detention in, is going to do absolutely nothing.
Mr. Costa, it's not required, based on your
It's not
testimony
required.
this evening.
I don't mean to go off on a tangent. I
Well,
have
you
the pulpit.
did, so.
Well, I did.
You heard the gentleman.
I did, because I think
Wasted
it's- I think
45
it's-
minutes.
I understand, but I think it's real, and I think we all live here.
I doesn't understand.
And that's that's my professional opinion, that's my personal opinion.
Are you running for office, Mr. Costa?
Maybe one day. If I do, there might be changes. Thank you.
Thank you. All right. You have about 10 minutes, so if you want to get started onto something, if you think you can get into it, I don't want to cut you short, though.
Chairman, I think it's best that I don't start Mr. Vergona's architectural testimony if I'm going to stop within 10 minutes. I don't think it's fair to the board. I don't think it's fair to Mr. Vergona. I know he's here and
Yeah, I know.
wants to show you his drawings.
I don't want to
but-
inconvenience him, but how much time do you think you'd need to get into something meaty, but then also stop? 15 minutes, 20 minutes?
Yeah, I would imagine. I would prefer, and maybe the board would agree, I would prefer to start Mr. Vergona's testimony and go through it. I don't want to try to give you 15 minutes and then say, okay, let's stop here.
So-
I don't think that's fair. I
So you'd
think
rather start him at the next meeting?
I
Mr.
prefer
Lampe?
to.
Okay.
Not to try to determine how you order a presentation, but how long would the traffic engineer be?
He's probably going to be longer than the
Longer than the architect?
architect.
I'm shocked.
So we're going to have an early night.
No argument.
All right. In that case, I assume you've completed your testimony.
I have.
Then this case is carried to the next meeting, which is, I think I said December 16th, at 7:30 PM without need for further notice.
That's notification to the public that it's carried to December 16th without any additional.
Okay. All right, does any member of the board have any old business? No old business.
Thank you, everybody.
Thank you. On new business, I'll mention that the board will be needing at least 2 new members. Maureen, your term ends this year, but you just started also, so I wonder, are you interested in being considered for reappointment to next year?
Yes.
Okay, so Steve, if you would notify the mayor that Maureen would like to be considered for reappointment for next year. Obviously, it's his decision and the council's decision, but by all means. So there will be 2 vacancies from the board at the end of this year. I would encourage any members of the public who are interested in serving on the Zoning Board of Adjustment to notify the mayor that, of their interest, and he can make a decision on whether to recommend an appointment, and then the council can decide whether they'll do it or not. Do we have any other new business?
Yes, Chairman. The 2025 calendar,
Yes.
you have that in front of you?
Oh, that, yeah.
Oh, yeah.
Yeah, I'm familiar with it, I made it out.
We checked in the office about any conflicts with holidays and things like that, and nothing came up. Something might come up with mayor and council, but I don't know yet, but we have to present this calendar to them
Yeah.
for their review. Does anybody have any issues with these dates? Do you want to get back to us by email if you do?
Again, it's remaining on the,
Yeah,
Yes,
still
it's
third Monday.
Third
Except for-
Monday.
Except for the holidays.
Yes, right.
Are the January and February meetings moved to the
They're
Wednesdays
moved
like
to
they
the
typically are?
Yes, they
Okay.
moved to the Wednesday after the holiday.
Okay.
So, I look at the religious holidays and try and avoid those. So I think it should be good until people decide it's not. Okay.
So you let me know if you have issues
Yeah.
by email,
Yeah.
other than that, we'll present it.
Good, yes, and deal with Steve on that. I'm out of it.
So if you and your partner in crime are abandoning us
Yes,
in one meeting,
yes, exactly. Well, our term of office is up.
how does this work?
Who's the partner in crime?
Emily is
Oh, come
also,
on.
yep, both of us are leaving the board at the end of the year. How this works is the following. The January meeting will be convened by the remaining officer. The board will then elect a chairman, a vice chairman, and a secretary, as they always do. Obviously, 2 of the officers won't be there anymore, so you've got one person who may or may not want to seek office, and then you have 6 other regular members from which you would select the other 2 officers, or 3 officers, as the case may be. I don't think we've ever had an alternate member become an officer, so that really wouldn't work out too well. But how that works out is, that's simple. You guys get to choose. And I don't know who the mayor will appoint for the other 2 points, whether that's someone who's previously served and you might consider one or both of those 2 individuals for an officer position, or maybe you'll say you want to select from people who are remaining at this time. That's entirely up to you, and I might watch it on TV. But that's the extent of it.
Just for entertainment purposes?
I may have my bag of popcorn and a drink.
You can man the camera.
That's it.
Also, if the members can't make it, some members have had issues attending, so I think if you still want to be on the board, and if everybody could let us know if they're not going to be attending. We really don't hear from anybody, and we have some empty seats, so.
Okay. All right, does anybody else have any other new business on the board? In that case, I'll open the meeting to the public. Does any member of the public wish to be heard? Not seeing a show of hands, I will close the meeting to the public. It's 10:18. Can I have a motion to adjourn? Do we have a second? All in favor? Aye. Any opposed? No. 10:18, meeting adjourned. Thank you all.